Hi, my name is Sanda. I'm joined by Sarah Chilton, a partner at CM Murray, and we are here to talk about age discrimination within partnerships. We had a look at one of the recent cases that kind of prompted this discussion, which is Scott and Walker Morris, which is around a partner who challenged the retirement age of his firm when he was compulsorily retired. And we thought that it would be good to have a chat around what the sort of the different obligations are for firms and potential areas of challenge for partners who are in firms who have a mandatory retirement age, and also just the principles around this area generally. First off, I think, Sarah, we wanted to have a little bit of a chat around whether or not you can be forced to retire at all because of your age. Is that something that a firm can do to a partner?
Well, the classic lawyer answer is it depends. And so, in theory, so in the UK, we have a law which prevents discrimination, which is less favourable treatment on the grounds of age. Interestingly, age discrimination is I'd say, special kind of discrimination where the discriminator, so in this case it would be the firm, can potentially justify an act of direct age discrimination. So, treating someone less favourably because of their age can potentially be okay. Think of it like a defence. So, you do it, you hold your hands up, but you say, but I did it because. And there's case law that thankfully helps us with kind of what you can put in that because box in terms of your justification. So yes, in some cases you can be lawfully, I guess, forced out because of your age out of whether it's a law firm or another professional practice. And we do see quite a lot of challenges around this area. So we do see still quite often, despite the general mandatory retirement age being sort of phased out from a lot of industries, we do see quite often in law firms that they do still have a retirement age written into their members' agreement, which stipulates that partners need to either leave the firm or leave the equity membership or in some way otherwise change their status, reduce their kind of contribution to the business at a particular age. I'd say those ages at the moment probably range from sort of 60 and upwards. It must be very uncommon now, I think, to see anything under 60, and they'll maybe go 60 to 67-ish. I don't think you see many above that. So yeah, that's my it depends answer.
I completely agree with that. It does depend. But if you have one of those sort of mandatory default retirement ages in your retirement deed, you're coming up to retirement age. I know you say that firms can justify it, but by looking at it, can you just say, well, this age is, I don't know, 65. It's just not legal. It can't be legal. I'm still I'm still in good condition to work. I still contribute to the firm. I'm a rainmaker. They can't rely on this. If you wanted to go down that route of challenging it, what are your options? What's the legal framework look like?
So, I mean, I think in this context, it's a little bit easier to think about it in terms of what does the firm have to do to justify that age that they've picked is one that is not unlawful. So, and to a degree, that will require the individual seeking to challenge it to gather some information, which isn't always an easy task. So, step one, you might find that difficult.
Yeah.
But things that, as a firm, you should be putting in place, and therefore, as an individual, if these are not in place, you may be able to challenge, are essentially looking at. I would think of it in terms of progressing through a sort of series of questions. My first question would be, well, why is it necessary in the first place? So the legal test is that there should be a legitimate aim in order to justify that retirement age. And that really is about, what is the purpose of it? What's it trying to do? And that aim should have some sort of social policy theme to it. So, for example, intergenerational fairness or preserving the dignity of workers who are older and perhaps not performing as highly as they were when they were younger, which in itself is perhaps a discriminatory concept, but, we have that. So they're probably the two most commonly looked at and used justifications for age-related retirement ages in professional services. And what essentially a firm needs to think about is, is there a reason as to why we need this? And reasons that firms might need a retirement age would be things like they have a problem with underperforming partners who are at a particular age or age range, and they struggle to performance manage those partners in a way that is dignified. So, it can become difficult, or they're finding that it's not a very dignified end to people's careers to be managed in a certain way. That obviously can be mitigated in other ways. So, for example, you could have a robust performance management process that is implemented right through someone's kind of tenure as a partner. So not necessarily something that needs to be done in a harsh and undignified way. Or other issues that we see are where firms, for example, are seeing associates leaving because they're not being made up to partner, perhaps if there is no space in the partnership or in the equity to allow those people to be promoted. And so they're seeing attrition at senior associate, senior consultant level, where people cannot get space in the partnership. So they're losing talent. And so that would kind of fall under that intergenerational fairness sort of heading. And so those are the reasons that firms would probably be primarily looking at whether or not they would be implementing a retirement age. So if you're a senior older partner, you'd be looking at, well, did these problems exist in my firm? Do I think my firm have actually got a legitimate aim/basis for implementing this retirement age and for basically trying to get rid of me when I've hit, say, 65?
And that can be quite a ripe area, I guess, for challenge, especially when we look at the recent case of Scott and Walker Morris, because you've kind of mentioned that a lot of firms might rely on intergenerational fairness and the dignity of partners and not wanting to manage them out via performance management. But also having that as a genuine reason. And it seems from that most recent case, one of the key takeaways really is you can't just pluck your legitimate aim out of the air. It absolutely has to be backed up by some sort of evidence or facts that is the true situation in your firm. So if, as the example you've given, you actually have no problem in trying to retain upcoming associates or attract laterals because the people are, hogging the equity, then you can't then just rely on that as your justification. And equally, I think you make the point around firms relying often on the dignity point where they may not have a robust performance management system. But I think nowadays, that's probably going to be a lot harder again to justify that as your legitimate aim, where a lot of firms have moved from a typical, I would say sort of lockstep where you just go on and you get your equity the older that you get, to a lot more active management of performance year on year, whereby maybe not many people's dignity is going to be that affected if the same thing that happened to them 10 years ago is happening to them now as they're approaching retirement age. So relying on that as a reason to get rid of people who have reached that age may not be legitimate. And so from the firm's perspective, obviously they have to do their work behind that to make sure that they're relying on something that they can actually prove. And from an individual's perspective, if you're going to look to poke holes, you might want to be asking questions around, well, what evidence do you have? How have you supported this? If you were not in the equity, if you weren't a partner at the time that this was adopted, you will need to find someone who can give you some answers, or at least steer you in the right direction as to what brought about the current age that's selected. When was it last reviewed? Because that's, I think, also an issue as well. If it's, well, we had the justification 10 years ago, but as you've kind of mentioned, things have moved on. People are working much later on in life. I don't think people make the assumptions anymore that, you reach out, you get over 60 and all of a sudden all your faculties go, so you can't work anymore. Things have changed. We've got a much older working population, people contributing much later on in life. And so I think there's ample kind of remit scope to challenge whether or not those aims are actually, genuine. And after you've kind of, if that's something that a firm can substantiate, that they do have a genuine aim, is that all they have to do? Is that done? And then you have to kind of walk away and say, well, that's good, I've had my time in this firm, goodbye.
No, you can further challenge. So there's this next concept. So it's legitimate aim, but there's this concept of proportionality. So the wording is, proportionate means of achieving legitimate aim, which means the method by which the firm is achieving that aim, i.e. the retirement age, which is normally what we see, albeit, these same concepts and arguments would be applied to other things that affect partners due to age. So, you might have annuity policies that encourage retirement. You might have benefits that only kick in at a certain age to basically try and get people to leave sooner rather than later. So they all kind of come into the same bucket. But this concept of proportionate means is essentially like saying, you couldn't have done that in a less discriminatory way. So the firm would have to basically say, we needed the retirement age of e.g. 65, and there was no other way of achieving our objective. Let's say that's to ensure that there's progression of younger people into the partnership from associate level and up. We couldn't have done that in any less discriminatory way than just implementing that straightforward retirement age. So firms need to think about alternatives. So, they need to think about whether they can implement some sort of benefits package or incentivization scheme or, a gradual reduction in equity. So where someone can remain a partner, but, they have to potentially give up some of the equity points over a particular period of time leading up to a particular age. Now, that in itself might also be discriminatory, but it is potentially less discriminatory in its impact than a just straightforward blunt retirement age. And so firms do need to consider a whole suite of options in terms of the things we see probably most commonly open for challenge. And also when we talk to firms, you picked up on the first one that we see, which is that often firms like the idea of a retirement age, but they don't actually have the problem that they need to fix. And I think because it was at some point accepted that you could have one, I think a lot of firms fall into the trap of just assuming that they can have one and then they need to find reasons as to why they can have one, which you mentioned. Whereas actually sometimes you dig a little bit and you realise that the problem that they are trying to fix never existed in the first place, or it might have existed, but if they don't have the evidence to back it up, they're going to struggle to succeed in an employment tribunal to defend their position. But then the second one is this lack of consideration as to alternatives. So you see that quite often in judgments or, when you're talking to law firms or accountancy firms about these sorts of things, that, not everyone always thinks about, could we actually achieve this same aim? Could we fix the same problem in a way that's less detrimental to the people that it will impact? And I think those are the two things that I think most open these retirement ages to challenge by individual partners.
I would add, though, just for partners to be aware of that the fact that there isn't evidence at the point in time at which it was adopted doesn't mean it can't be justified by the time it gets to tribunal, because the tribunals are still willing to look at kind of current evidence that suggests that the mandatory retirement age is still required.
Yeah.
So the reason that we would, though, encourage a regular review is because you still may not be able to do that in real time if the problem that you think you have doesn't exist.
Yeah.
It didn't existed 10 years ago, it doesn't exist now, or it never existed 10 years ago and it still doesn't exist now.
Yeah.
So it's still a thing to, still something to keep in mind. But if you might have a firm who sort of comes back and responds with, well, yes, we don't have any evidence, any paper evidence at all, but we've looked at this again and these are our justifications. We can back it up now. In the last 2-3 years, we've had a whole team of, associates leave, and they cited in their exit interviews, the reason was because there was just no room for growth in the firm. Then even though that didn't happen 10 years ago, they could potentially rely on that now. So it is a kind of, moving feast, and a little bit, it might not be as straightforward as saying they've not produced any evidence, from 10 years ago. And so that means I'll have a slam dunk case in proving that they've not got any objective justification. I think it's an interesting area that we see happen in practice quite a lot. And I think for firms anyway, it's worthwhile properly focusing on, as you say, alternatives, just for the benefit of the firm itself, the health of a firm, how, the collegiality, how other people feel. At some point, the management of the firm will probably reach that retirement age as well. It will become a personal issue for them. So for everyone, it does need to be addressed and dealt with. And for individual partners, if they are, I think if they find themselves in the position that they're approaching retirement age and they're starting to think, hold on a minute, maybe this isn't quite right, there are things that they can look at, hopefully to challenge, and if not in the wider firm, get changed before they're about to leave, maybe at least get some leverage to agree a package or agree something on their way out if they're not prepared to challenge it all the way to an employment tribunal, for example.
Yeah, because that in itself is quite a lengthy and costly process. And often you see the cases that get reported, the person might challenge the age when they turn 60 or 65. And by the time they get a judgment, they're, 67, 68. And they've battled for those last few years whilst actually being out of the business. So it's not, an attractive proposition for anyone really to take, although sometimes necessary and justified. It's an interesting area.
Definitely. So hopefully that's given some of our viewers a little bit of a kind of high level overview of age discrimination in partnerships. And of course, as ever, if anybody ever has any questions or going through the issue personally themselves and they need advice, contact us. We are always happy to help.
Yeah. Thanks, Wonu.